What's up, everybody? Little vacation special here as a lot of stuff is happening. Of course, that's okay because it's still fun. It's early here. Nobody else is awake besides me and Wit. So we're just hanging out. And I saw a bunch of people tag me on Twitter for the newest Alec Murdaugh doc via Fitz News, where most of the documents are coming from. I have a nice little setup here in my buddy's pool house that we're staying with. And he worked with some basketball players. So if anybody can guess, this shoulder, whose shoe this is, maybe we'll do a giveaway of some merch. I brought him some merch as well. And then some of the jerseys that are signed under it, I'll talk to him. Maybe I can show them to some of you guys in some of the future lives. But really cool setup back here. It's been fun. We're eating good food, not sleeping a ton. Had an early flight yesterday and hung out, walked around a lot. But this new document that I was tagged in was really interesting because when we have this jury questioning that's going to be happening in this case, even though Murdaugh's team is looking like they're going to lose because of the burden, they're still protecting everything for the appeal and still pushing to get information that will help them, even if they lose this argument at this point, that they may get information that would be helpful in the future. I also think it's interesting that are they actually asking for this first juror interview that's happening before all the other juror interviews to be closed to the public? And if they are, why? Why do they want it closed to the public? And of course, more shots at Eric Bland by Murdaugh and his team. So we're going to get into these documents. We're going to read them together today. And then at the end, we're going to actually see the examples of questions that Murdaugh's team wants to ask the jurors. Now, we went through this with Maya to hear what the lawyers wanted to ask versus what the judge wanted to ask. Judge asked some of the lawyers' questions, not all of them. I'm not so sure how that's going to go in this case, but nevertheless, we're going to at least get to see what Murdaugh and his team want to ask. And again, documenting them protects it, puts it on the record. If the judge says no and later an appellate court disagrees, maybe Murdaugh will gain some traction there. So thanks for joining me. Hit that like button if you guys haven't already. Throw a guess in the chat as to whose humongous shoe this is behind me. It's literally the size of my entire arm. Like, if you just get an idea of how humongous this shoe is, it's a big one, as they say. It's a big one. All right, let's get into this letter received literally today, written yesterday, to Chief Justice Toll. I write in response to the email from Ms. Diaz, dated January 24th, communicating your desire for responses from counsel to the court's proposed questions for jurors for suggested questions and topics for the examination for Rebecca Hill. I've attached Mr. Murdaugh's proposed juror questions as Exhibit A to this letter. Mr. Murdaugh objects to the court's first proposed question. So we don't have all the court's questions, but we're going to get to know a little bit about some of them because Alec Murdaugh and his team are going to object to some of those questions. And here's the court's question they're objecting to. The verdict of guilty you rendered on March 2nd, 2023, is that currently your verdict in this case? Is that currently your verdict in this case? Meaning, is your verdict the same? The issue under the legal standard adopted by the court is whether Ms. Hill made comments during the trial that affected the vote of any juror on March 2nd, 2023. So he's basically going to start arguing here. What I expect him to start arguing here is, Judge, right now you're saying is your verdict the same? Okay, fine. Their verdict may be the same. That doesn't mean Becky Hill did not affect their original verdict, and they continue to believe it and think that she was right in what she said about Murdaugh and his team, and therefore their verdict would be the same. So that's not an appropriate question. It's going to sound worse than it actually is for us. Mr. Murdaugh objected to that standard, but he already lost that. Still going to reiterate that they object to that standard, but even under it, what a juror would or would not do a year after the trial has no possible relevance to any issue before the court. That makes me think that even Murdaugh's jurors, or the jurors that are friendly to Murdaugh, are not going to say they have a changed verdict a year later. Judge Hawker did pose a similar question to the jurors in green, which we know they used in their arguments, but he did so when polling the jurors immediately after the verdict and before they were discharged. Here, a year has passed since the start of the Murdaugh trial. Asking jurors how they feel about the verdict today is both irrelevant and prejudicial, in that it invites jurors to consider a full year of post-trial media coverage when answering questions about events during trial. Further, if a juror did answer no, the court would be compelled to ask why, which could have only two possible answers: some irrelevant consideration arising after the verdict, or reflection on some perceived defect in jury deliberations as to which the juror could not testify to under Rule 606B of South Carolina Rules of Evidence. I actually agree with Murdaugh's defense team here. I don't think this question makes sense. I don't think the court should ask it. I don't think it matters. And any reason their verdict would have changed, unless it was because Becky Hill influenced them some way, really has nothing to do with why we're here. Mr. Murdaugh objects to the court's second proposed question. Was and is your verdict based entirely on the testimony, evidence, and law presented to you in this case? So this is exactly what I expected the court to ask and what I expected Murdaugh's team to object to. Murdaugh's team wants to ask more these questions backwards. Did you talk to Becky Hill? Did she influence your verdict? And then if your verdict was guilty, fine. And maybe your verdict would have been guilty anyways, but Becky Hill's influence helped or added to you voting guilty, and therefore they can argue prejudice. That's how they want to ask it. The court wants to start at the back end and then work its way forward, if that makes sense. This question violates Rule 606B, which provides in part, upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment, or concerning the juror's mental processes in connection therewith. So the point of that is we don't want to get into the province of the jury, as they say, figure out what was talked about and give lawyers more fodder for arguments about, oh, they said this or said that, and they shouldn't have in the jury room. It's secret. It's protected. What Murdaugh's team at this point I don't think is getting is the judge is not going to rule in line with these rules and these cases that they're arguing say you can't get into the province of the jury, because she's saying that's exactly what we need to do. We basically need to figure out what was in their head, why they made the decision, and is what Ms. Hill said something that factored in to push them to guilty and therefore prejudiced Alec Murdaugh. So I get these arguments. I understand them. I think they've worked in the past in other cases, but I don't think they're going to work here. This question violates the rule because it directly asks the juror what did or did not have an effect upon that juror's mind or emotions as influencing the juror to assent or to dissent from the verdict. Mr. Murdaugh understands the court has decided to directly ask the jurors about what affected their verdict. There you go. Because it is held prejudice must be proven by evidence on that point rather than presumed based on the source and content of the illicit communications per federal authorities such as Remmer. Again, remaking the same argument that's already lost. So Murdaugh asserts his objection for preservation purposes, meaning protecting the record so they can make this argument again later on appeal. Additionally, Mr. Murdaugh objects that the second proposed question is highly suggestive of an affirmative answer. It could and likely would cause a juror to reasonably believe the court prefers he or she give an affirmative answer. This is just the way the court is asking the question. Questioning of witnesses by a judge. This is the trial handbook. The primary purpose of the trial judge's questioning should be to clarify and promote a better understanding of the witness's testimony, to elicit the truth, and to cover matters omitted by inadvertence or any other cause. This question is unnecessarily convoluted and indirect way of asking the question that needs to be asked. Reserving his objection to the court's rejection of the controlling legal standard and his Rule 606B objection, Mr. Murdaugh submits that under the court's prior ruling on the legal standard, the proper inquiry is 1, did you hear Ms. Hill say anything about the merits during trial? And if so, 2, did it in any way influence your verdict decision on March 2nd, 2023? So you can also, we have in our mind, right? We're reading this. It's lawyers speaking. There's some vagary and some, abstract discussion about what jurors may or may not say to these questions. But we can feel pretty confident that Murdaugh's team knows how at least one voting juror is going to answer these questions, and maybe some alternates or dismissed jurors. So we have to keep that in mind, especially as we read later when they say it's unfair that certain jurors might know what's coming. The court should ask those questions plainly and directly without language mirroring the judge's jury charge or otherwise suggesting a correct answer, and without requiring additional inferences to get to the actual issue before the court. Instead of asking a juror whether your verdict was entirely based on A to infer that it was therefore not influenced by B, the court should just ask whether the verdict was influenced by B. And this is actually similar to some of the arguments J. Hatch made. It's like, Judge, if you say, did you violate the court's order? Obviously, anybody's going to say no to that. But if you say something like, well, did you just discuss the verdict with your wife in Maya's case? Then maybe we'd get a better answer. Similar to the argument Murdaugh's team's trying to make. Don't ask if they just based it on the evidence. Ask, with all that evidence, did what Miss Becky said influence you at all? Leaving it open for them to say, yeah, it was the evidence, but also discussions. And as opposed to them just taking the easy answer and say, yeah, I voted completely based on the evidence. Again, something I don't think is going to win the day with this court. Mr. Murdaugh objects to the court's third proposed question. So we're 3 for 3 so far. Was your verdict influenced in any way with any communications by clerk of court Becky Hill in this case? This question directly violates 606B for the same reason mentioned above. Mr. Murdaugh additionally objects to the language, your verdict is unclear. It could be taken to mean the juror's own vote, or it could be understood more literally to mean the collective decision of the jury of which the juror was a member. Mr. Murdaugh also objects to asking this question before asking the juror whether he or she heard any comments on the merits by Miss Becky. If a juror heard no comments, there's no reason to ask the question. I agree with him there. So it's going to seem like more evidence for the other side when in reality it's not, because they didn't hear the questions. But if this is prejudicial, how many jurors had to hear it, right? I think it's just one. What's this court going to say? So he wants to reserve his objection there, and he thinks there should be some question, or the question should be rephrased similar to this. Did Ms. Hill's comments prejudice you against the defendant, Alec Murdaugh, in any way? You can see what it's like to be a lawyer and why a lot of this is better done in trial when lawyers have to think on their feet. If they have an objection, they can say it there as opposed to taking the questions home. It's like a take-home test. Not a lot of those in law school, although I think I did have one, where you can take it home and you can look up every different way to ask a question and pick apart every single word and comma and phraseology and what words you put before this word. And you should ask it this way first, not that way. And they would pick apart every question. So it's not unusual for lawyers to have problems with the way questions are asked. Mr. Murdaugh objects to the court's fourth question, 4 for 4. Did you have any communication with Becky Hill about your verdict in this case? And the follow-up is, if yes, what did she say? Because have any communication with Becky Hill is an unclear statement. Mr. Murdaugh suggests a more clear and direct question. Did you hear Ms. Hill make any comments about the testimony, evidence, or arguments presented by the state or defense during the Murdaugh trial? I think that's fair, and I think the defense actually right here. I think the court asked in a vague way, and they did have conversations with Ms. Becky, but like, what do you want for lunch? Obviously didn't affect the verdict. So why don't we just ask them? Did you have any conversations about the stuff we're here to talk about with Ms. Becky? If the answer is yes, asking what was said, Mr. Murdaugh believes the court should ask when it was said, where it was said, who else was present when it was said, and as explained above, Murdaugh believes what, if anything, was heard should be asked before the court asks what effect it had. Mr. Murdaugh again objects to including counsel for jurors participating in the merits of this proceeding for the reasons previously briefed. He respectfully submits that the court should not have included Eric Bland in correspondence discussing what questions will be posed to his client. Don't tell Eric Bland ahead of time what questions should be asked to his client. I kind of agree with the defense. I am aware of no precedent for a court providing a witness's lawyer with an advance copy of the questions the witnesses will be asked during a criminal proceeding. I agree. Fortunately, there was no prejudice to Mr. Murdaugh because the court granted Mr. Murdaugh's request to sequester the witness, and Mr. Bland agreed to abide by the court's order, which means Mr. Bland agreed not to talk about this with his client, also agreeing that this isn't a situation where you're prepping a witness to come answer questions by a lawyer. So Mr. Murdaugh's team just wanted to put it on record, take a little shot at Eric Bland, even though they agree, no prejudice to Mr. Murdaugh. However, the examination of Juror 826 is held in public tomorrow, which is the one that had to be done ahead of time, that Bland also represents. The attendant media coverage means the other witnesses will not be sequestered and will be given advance notice of the questions they will be asked and an opportunity to discuss their answers with others. Mr. Murdaugh therefore objects to holding tomorrow's hearing in public, which is today, and requests the court be sealed with a transcript and perhaps an audio recording released on Monday once the juror witnesses are assembled in the courthouse. The public interest in observing The examination of a single witness 1 business day in advance of the actual hearing is minimal and is outweighed by Mr. Murdaugh's interest in witness sequestration. For example, the juror witnesses are in communication with each other through some group chat for which Mr. Murdaugh can provide document. Oh, they are. He knows that. They have documentary evidence. Same as the Maya case. Mr. Murdaugh should not lose the ability to seek sequestration of witnesses simply because he, the state, and the court wish to accommodate an innocent juror's prepaid travel plans. So this is an interesting argument, and I actually think holds a lot of weight as to why maybe close off the questioning of this one juror so the other jurors can't all talk about it. It keeps the sequestration in order. It still keeps the right of the public in place because the public is still going to get to watch next week. So all that is still not hurt by this, but in an abundance of caution, why not? Especially because Mr. Murdaugh and his team agreed to change the rules for this juror to accommodate this juror and have the questioning done early because of prepaid travel plans, and they shouldn't be punished for that, potentially prejudicing them if this juror is allowed to, or if media and everybody else is allowed to talk to the other jurors about the questions asked to this individual juror. Mr. Murdaugh objects to the court examining Ms. Hill at all. Rule 614B of the South Carolina Rules of Evidence said, when required by the interest of justice only, the court may interrogate witnesses. This restriction is almost unique to South Carolina jurisprudence. It does not appear in Federal Rule 614, and Florida is the only other state with this restriction in its corresponding rule. And we heard about that in Maya. Ms. Hill is an elected public official accused of wrongdoing, which she has denied by a sworn statement filed with this court. She is the state's principal witness against Mr. Murdaugh. The prosecution and SLED agents just held a 4-hour pre-preparation session with her to coach her testimony, even though they are supposedly investigating multiple criminal allegations against her. That is one of the most frustrating, I can't highlight it here, frustrating things to hear. The state of South Carolina, all this negative crap about Becky Hill's coming out and what's happening, the prosecution and SLED is still, according to Murdaugh's team, allegedly working with her for 4+ hours to prepare her testimony for this. It's not a good look. If you want transparency and justice, and there's not 2 justice systems, right? That's what the AG's office said. It's not 2 justice systems, one for the powerful like Murdaugh. Well, are there 2 justice systems? One if you work for the state, and one if you don't? Because there shouldn't be 2 justice systems there either. She's got a lawyer. Let her lawyer prep her for this. So I don't love hearing that, just for the betterment of South Carolina justice system. There is no reason the interest of justice will require her to be shielded from being asked questions in the same manner as almost every other witness in every other case in the history of this state. The court has not stated any reasons for conducting the examination of Ms. Hill itself, and if the court is determined to do so, Mr. Murdaugh respectfully requests the court state its reasons on the record prior to her examination. Why would Murdaugh's team want the court to state its reasons on the record? For appellate purposes. So if there are the wrong reasons or reasons that don't rise to the level of the interest of justice being in play here, then it could be an appellate issue. Mr. Murdaugh has a right to present any evidence relevant to his claims, which is not prohibited by the Constitution of the United States, the Constitution of the State of South Carolina, statutes, etc. Relevant evidence means evidence having the tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Witness credibility is also always relevant. So this is the same argument he's made before, using some case law, that they should be able to ask Ms. Hill questions, impeach her with the problems that they have found. Whether Ms. Hill lied to the court during trial about a matter of the jury is probative of whether she is now lying to the same court about her contacts with jurors during trial. For that reason, inquiry by counsel should be made into the Facebook matter. I agree, because if she did something to get a juror booted, that's absolutely relevant to her influencing the verdict. That's my opinion. Plagiarizing the book that she purportedly wrote about the trial is probative of her truthfulness about her conduct during the trial. That, I think, might be a step too far. Inquiry should therefore be made into that matter. Whether Ms. Hill stated during the trial that she had a financial interest in a guilty verdict is probative of the truth of her denial of the allegations that she acted to secure a guilty verdict. I agree with them there. So far, I agree with 2 out of 3 that they're pushing here to inquire with Ms. Hill. Inquiry should therefore be made into that. Abusing the power of her office to steal money is probative of whether or not she, at about the same time, abused the power of her office for financial gain in other ways. I don't agree that has anything to do with this case necessarily. Again, if there are further prosecutions or sanction hearings or ethics violation hearings for Ms. Hill, all that's relevant to this, probably not so much. Inquiry should be made about that. Abusing the power of her office to steal money. Financial gain. Proof of bias is almost always relevant because the jury, as finder of fact and weigher of credibility, has historically been entitled to possess all evidence which might bear on the accuracy and truth of a witness. An inquiry should therefore be made into the allegations that Ms. Hill sold access to the courthouse and otherwise misappropriated funds to the point that during trial she was not even allowed to have county credit card. So I don't see how that's necessarily relevant except to make her look bad, and I get it. That's what they want to do. All right, almost done here. The evidentiary rules prevent witness impeachment from turning into a trial within a trial by prohibiting the introduction of extrinsic evidence regarding specific instances of conduct, instead generally limiting it to prior inconsistent statements and evidence of bias. Those rules are sufficient to contain the defendant's examination of Ms. Hill. There's no need for the court to go further and rob Mr. Murdaugh his right of cross-examination of Ms. Hill. And basically what they're worried about is they want to ask about all this stuff. The court doesn't want him to ask about all this stuff. So is the court going to ask the questions to make sure Murdaugh and his team doesn't ask about all that stuff? For example, she's already admitted publicly to plagiarism. So that line of questioning will be over in a minute. So why need it, right? If the court already knows that, why do you need that? And you already have it on the record, basically. But that's why they want it. At a minimum, if she denies speaking with jurors about the merits, Mr. Murdaugh should at least be allowed to call any percipient witness, eyewitness, who would contradict her, meaning egg lady and alternate jurors who did not sit there and deliberate, but they want to get their testimony on the record as well. The court right now is not allowing it. Testimony of those witnesses likely would take less than 10 minutes. Whether those witnesses later deliberated with the jury is irrelevant. Ms. Hill, after all, did not deliberate with the jury either. She too is relevant only as an eyewitness to her actions. So that's a good point. Ms. Hill and these jurors have some similar testimony that they're going to bring. But also what's interesting about this is Murdaugh's team knows exactly what a lot of these jurors or alternate jurors are going to say. And they're arguing that it's not fair if Eric Bland or some of the other lawyers for the other jurors know what those jurors are going to say to answer the questions. Kind of having it both ways. When ruling that Mr. Murdaugh will be prohibited from calling percipient eyewitnesses to Ms. Hill's alleged jury tampering statements, whether to corroborate jurors who testify Ms. Hill made such statements or to rebut Ms. Hill's sworn denial of making such statements, the court stated, the corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter. We remember the court saying that. Mr. Murdaugh objects to those statements. He has a right to challenge the credibility of the state's principal witness against him through cross-examination, which is not contingent on how the court perceives its own needs or capabilities. That would be like a juror saying, I don't think I need to hear the rest of the evidence. I think I know what my answer is now, Judge, which they cannot do for obvious reasons. Observing the right to cross-examination is one that must remain inviolate. The power of cross-examination certainly is one of the most efficacious tests which the law has devised for the discovery of truth. And it is one of the most inestimable rights by which a man may maintain his defense. Respectfully, it is inappropriate for the court to direct the parties' factual presentations based on its own opinions, formed before receiving any evidence about what it needs to assess witness credibility. I do agree with them there. I didn't really have as much of a problem with it. I knew it was going to sting, but they are making a good point. The parties decide and present within the limits set by the South Carolina Rules of Evidence what they believe the court needs to make the findings of fact. And also, if they disagree with what the court decides, it's all on record for them to appeal. It is Mr. Murdaugh's burden to prove his allegations, not the court's. It is the state's burden to rebut Mr. Murdaugh's proof, not the court's. This is an American adversarial proceeding in a trial court, not a European inquisitorial proceeding conducted by an investigating magistrate. With warm and personal regards, I am sincerely Dick Harpoolian. All right. So we'll see, because I think they do make some pretty good points there. I agree with part of what they want to go into with Becky Hill, but not everything. Basically, the way I see it is, If it's directly connected to these jurors, this case, and this verdict, they should be able to ask her. If it's connected to her book or money or other nefarious things that she may be involved in, I can understand why the court doesn't want to ask that. I absolutely think the court should ask the question to the jurors and the lawyers should ask the questions for Ms. Hill. She has a lawyer there. He can object. She can plead the fifth, maybe. There are protections in place. I think the lawyer should be able to question her personally. All right, so here are the exact questions Murdaugh's team thinks the court should ask the jurors. Did you hear Ms. Hill make any comments about the testimony, evidence, or arguments presented by the state or defense or the anticipated length of your deliberations during Murdaugh's trial? So if they say yes to that, okay, it opens up the floodgates to future questions. If they say no, it pretty much checks all the boxes that they're not going to have relevant testimony to this. So if the answer is no, no further questions. If the answer is yes, then we follow up. What comments did you hear Ms. Hill make? And again, it can be about the evidence, the arguments, the state, the defense, anticipated length of deliberations. Or maybe they say, she told us what time lunch was coming. Maybe they don't fully understand the first question and they'll just say anything they heard Ms. Hill say. Next, who else was present when Ms. Hill made those comments? That's like a discovery question. We always ask, who was there? Who else did you tell? So we can get all these other names so we know these are all these other witnesses that we can depose in this case. So maybe Murdaugh's team doesn't even know certain people were there when Ms. Hill said this. Maybe it's a bailiff. Maybe it's somebody else who said Ms. Hill never said anything to these jurors, and now they can impeach those people with the testimony of these jurors. That's why it's an information gathering event here. Did Ms. Hill's comments influence you in any way? And if so, how? No, they didn't. Yes, they did. They made me rush my verdict and just agree with the other people, even though I wasn't sure it was guilty, but now I feel comfortable with guilty. That would be prejudice. Well, I wasn't so sure. I kind of did believe Murdaugh and his team, but once she said that, she was right, and I didn't believe him anymore, and they were guilty. Prejudice, obviously. We'll see how they answer. Did Ms. Hill's comments prejudice you against defendant Alex Murdaugh in any way, however slight? So this is sometimes harder for jurors to understand exactly what that means, so the prior question may help with that. But again, if they say yes to this, obviously there's going to be a guaranteed new trial. I don't really expect any of them to say yes to this. I would be surprised if any of them said yes to this. What do you think? Do you think anybody will say yes to this? All right, we'll see if this juror questioning is going to happen open to the public. I probably will miss it because we're about to head out and hang out for the day. But I appreciate you guys who joined, who hung out, who hit that like button, who asked your question in the comments. Let me know who you think's, gosh, I keep missing the shoulder, whose shoe you think that is. Maybe we'll do some more coverage on Kohberger later this weekend from LA. But for now, that's all I got. I appreciate everybody who came and joined. But until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.